Welcome to Breaking the Debt Cycle, Gaining Your Financial Freedom from Credit Cards.
Hello and welcome to Breaking the Debt Cycle, Gaining Your Financial Freedom from Credit Cards with attorney Michael Sheridan. Michael is a seasoned bankruptcy attorney serving clients across Minnesota at Atlas Law Firm. He helps people navigate the stress of overwhelming debt with clarity, compassion, and personalized legal solutions. I'm Lisa Mosby, your host, and today we're answering a question that comes up in nearly every bankruptcy conversation. Will I lose my car? Let's get into this, Mike. Thanks for being with me today.
Thanks for having me, Lisa. Happy to be here.
Yeah, if
Um,
someone files for bankruptcy, are they automatically going to lose their car?
no, not at all. So, and I've talked about this a few different times, but it's a huge topic in bankruptcy, so it always bears repeating. When you file for bankruptcy, and the two most common chapters for individuals are Chapter 7 and Chapter 13. And that's the same if you own a business or not. There are a lot of people who are business owners who have business-related debts, who have personally guaranteed, and who are looking for bankruptcy as well. And so the question becomes, okay, what happens to the assets, regardless of whether they're personal assets or business assets? And so the answer is you have to disclose all of your assets, and then we apply the protections to those assets. The protections are called exemptions. And under Minnesota law, we can either use the Minnesota state exemptions or the federal exemptions. And so the exemptions are the various protections for your assets. And one of the protections is for your vehicle. Now, the vehicle protection is a little unique because on a lot of these exemptions, you can kind of spread around the protection to various assets. So, for example, your household goods, your furniture, your clothing, there's kind of a blanket category of protection for that. And there's a set amount. And it's extraordinarily rare that we ever have any issues protecting our clients' household goods. So you can kind of spread the money around to various things. Well, the vehicle exemption, the way those laws are written is you can only apply your vehicle exemption to one vehicle that's titled in your name. So for married couples who are filing jointly, or for individuals who own businesses and perhaps the business is on the title to the vehicle, those ownership interests in your bankruptcy don't have to be protected because they're not your interests. So for example, if I own a car jointly with my spouse, and this vehicle is worth $5,000. But for whatever reason, I decide only I need to file bankruptcy. My spouse does not need to file. And I disclose that vehicle as one of my assets. Well, I wouldn't say I own that entire vehicle. I don't have a $5,000 interest in that $5,000 vehicle. I have a 1/2 interest in that $5,000 vehicle. So that vehicle is worth, my interest is worth $2,500. And so you would apply that protection, which under the federal exemptions currently is just under $5,000. So that vehicle, as long as I have a 1/2 interest, I can protect it, no problem. And I don't have to protect my spouse's 1/2 interest because that person isn't filing with me, right? Now let's change the situation where it is, I've got a 1/2 interest in a $5,000 vehicle and I've got a 1/2 interest in a $10,000 vehicle, right? And this is very common in married couples. Hey, we both have our names on title, but this car is yours and that car is mine, but we both own them both. Well, in bankruptcy, who's on title definitely matters in terms of if we can apply the protections. So now let's say I'm hypothetical. I'm filing bankruptcy. My spouse is not. I've got two vehicles. I've got a 1/2 interest in both of those vehicles, as does my spouse. One's worth $2,500, my 1/2 interest, and the other 1/2 interest is worth $5,000 in a $10,000 vehicle. Well, I have one $5,000 exemption. So where do I put it? I can't split it between the two. I can't say I'm going to put 25 over here and the other 25 on the other vehicle because I can't spread them around. I can only choose one vehicle to put the 5 on. Well, what do I do? Well, when you work in this area for not too long, it becomes very clear. You want to maximize the 5,000. So you put the 5,000 on the 5,000 interest. And now we have $2,500 that needs to be protected otherwise or has to be resolved with the bankruptcy estate. And so the federal exemptions that I've been mentioning, they have various categories. And one of them is the vehicle exemption. Now, there's another category called wild card, and that can be up to $17,500 of protection. However, under the federal exemptions, if you have more than $37,000 of equity in your home, you can't protect that home, so you're not using the federal exemptions. Let's say you've got $20,000 of equity in your home. We've determined your house is worth $200,000 and you got a $180,000 mortgage against it. You've got $20,000 of equity. So $20,000 of equity, you've got somewhere in the neighborhood of $15,000 of wild card left over. Okay. So I take 5 to protect my $5,000 half interest, and then I take $2,500 from my $15,000 of wild card to protect my other. And so that's kind of how this works. It's a moving jigsaw puzzle that varies on a case-by-case basis. Do you have 100% interest in the vehicle? Do you have interest in multiple vehicles? And how much equity do you have in your home? Because if you have more than $37,000 of equity in your home, we can still very likely protect it, but now we're using the Minnesota state exemptions to protect your assets. And we can't mix and match the federal and state. It's either or. So if we're in the Minnesota state exemptions because maybe you have $80,000 of equity in your home, well, the Minnesota state exemptions, they mechanically work the same way, but now the value limit is different because under the Minnesota state exemptions, you can exempt or protect up to $10,000 in your vehicle. And that's the equity again. But again, it only applies to one vehicle. So if you and your spouse or you and another person, or maybe you co-signed on somebody's car, that is considered an interest in a vehicle. Now, if you co-sign on a car and the other person is making all the payments, we then call that an equitable interest. And realistically, even though you have a legal interest in your own title, if somebody else has made all the payments, really the vehicle is theirs. And the trustees work with us on that, and they just have us confirm it. But let's say hypothetically, you've got a business, and instead of a spouse, let's say I've got my vehicle. I've got two. Let's say I plow roads in the winter, and I've got 2 trucks with plows on them. They're both worth $10,000 with their mileage and their age, and they're both in my name, but they're really for company purposes. For vehicles that are used as a business tool, you actually have additional exemption under the Minnesota state exemptions. And that number, fluctuates over time, but it's a big number. And, based on your circumstances, the legislature has put the protections in place to protect enough assets that you can continue living your life. Again, this kind of gets back to what the focus of the bankruptcy laws are. And I think we're just kind of conditioned over time. A lot of us don't consider bankruptcy because when you take out debt, you intend to make the payments, and most people do. And you make your payments until something happens and you can't. And, for a lot of people who have the income and nothing has changed and everything's going hunky-dory, you don't have to consider bankruptcy. So you just kind of think, oh, it must be for, people who are just reckless or just, not disciplined with their money. And there must be some kind of punishment component, like they'll cancel your debt, but they're going to destroy your credit and they'll take all your assets and you'll lose your job and you just have to start over from square one. And that's 180 degrees from what the law is actually focused on. The law is about allowing you to protect your assets so that you can use your income and your assets to protect you and your dependents and to be able to raise your children and feed yourself. So there's no mechanism to automatically take away your vehicle. Now, the intent behind these exemption laws is, again, to protect your stuff, but they got to draw a line somewhere. If you came in and you said, I've got a $3 million mansion and a gold-plated car and a rocket that I can fly around the moon, they'd say, well, maybe you should sell some of those large assets and pay off your debts. But at the end of the day, there's a certain line where, hey, we bought this house. We've been working at buying this so we have something to retire and not, so we this is for our family. And the court's not going to take it away from you to punish you. You have rights, and that's what the bankruptcy laws are focused on protecting for you when you get into trouble with debt. And certainly, if you can avoid filing bankruptcy, you should. But if you find yourself in a position where you have to choose between paying living expenses and paying credit cards, or you've got 25% of your paycheck getting taken because somebody has a judgment against you and you can't afford to pay your mortgage, or you have to go to the food bank because grocery prices have gone so high, you don't have to be worried that you're going to lose everything. Because I can tell you for a very large percentage of my clients, I would estimate somewhere in the upper 80% range, we're able to protect absolutely everything in terms of their assets, their home, their vehicles, their retirement account, their household goods, their tax refunds. Those things are assets that we use to meet our living expenses. And at the end of the day, the court's not going to interfere with your ability to care for yourself and your dependents. And the fact of the matter is, we need vehicles. But if you're trying to keep a $200,000 Rolls Royce, the court's going to say that's more vehicle than you really need. So let's draw a line somewhere. And again, let's say you have a vehicle that's beyond what we have protection for, they're not going to automatically take it from you. The court official assigned to your case, the trustee, in a Chapter 7 is going to work out a payment plan with you. They don't want the vehicle, they want the value. And the trustee is willing to work with you as long as they think your valuation is correct and you're not playing games with them. They'll work on a payment plan. And so even if you don't have full protection, you can still keep the asset and pay off the small amount that's unprotected. And of course, if you have a loan against your vehicle, that's a secured debt. They have a lien against that vehicle. And so you have to continue paying them even after the bankruptcy is filed. Now, the caveat to that, to take us off on a tangent, because I know, Lisa, you love tangents, to take us off on a tangent in Chapter 13, you can actually do what's called a cram down on a car loan. And if circumstances are right, which basically means you've had your car loan for at least 910 days prior to the Chapter 13, and your vehicle is underwater, the vehicle value is less than the balance owed against it, then you can cram down the loan, the secured loan, on that collateral through your Chapter 13. And so if the circumstances are right again, you pay your car loan through the Chapter 13. You make your payments to the trustee distributes the payments to the creditors in a Chapter 13. And so let's say, hypothetically, I've got a $18,000 car loan on a $11,000 vehicle. Just because of the mileage, the wear and tear, online you look, it's pretty clear the car is worth less than it's owed against it. So through your Chapter 13, you can say, I'm going to pay what the value of the collateral is. It's $11,000. And that's the amount that the secured creditor is going to get, the value of the collateral. But then the difference between the value of the collateral and the balance of the loan, which in my little example is about $7,000, that money is treated as unsecured debt. It's crammed down into the pool of unsecured debt. And unsecured debt through Chapter 13 doesn't necessarily have to be paid in full. They're just getting what you can afford to pay them over the 5 years. So it technically could be zero. So in a Chapter 13, you are enforcing your rights even over and above that of the creditor. And you're saying, yeah, you have a lien in this vehicle, and it was worth 18 approximately, X number of years ago when I bought the vehicle, but now the vehicle is depreciated and you bear part of that loss as I do as the vehicle owner in Chapter 13. And so I'm only going to pay you what the vehicle's worth now. And the rest of it, you might get some payment on it, but it's really just frosting at this point in Chapter 13. So again, I go into that example because it illustrates for people how powerful these laws are and how they are designed to protect you. And ultimately, they're designed to balance the rights of the individual, what we call the debtor, the person who owes the money, and the creditors, the people to whom you owe money. And so, you can't just wipe away all the debt and have tons of assets and live in luxury. But at the end of the day, our economy is almost entirely built on consumer credit. So there are a lot of people who are living on credit cards, who are using credit cards as a source of income to address their monthly living expenses. So if you can keep the payments up while you pay credit cards and your living expenses, that's great. That's where a lot of people are. But again, if something happens to you and your income during this time that you're addressing all these expenses and debts, it obviously becomes very difficult to maintain the payments on both. And so the debts go, or the expenses, or both. And over a period of time, at some point of not receiving payment from you, your creditors are going to move to the legal process and try to get a judgment. And after they get a judgment, they can garnish up to 25% of your wages or levy money out of your bank account. And then at that point, you have to look at a cost-benefit analysis. What is the way that I can resolve this debt issue in a most cost-efficient way? And when you look at Chapter 7 or Chapter 13, you are factoring in the cost of your legal services and, potentially the cost of any payment plans you might need for potentially unprotected assets, but it's probably going to be pretty low based on my experience, versus, how much it would cost to pay off the remaining debt at the interest rate over, whatever payments you're making. If you're making the minimum payments, it's going to take quite a long time. Obviously, it's dependent on what the principal and the interest is. But you can protect yourself and your assets by filing for Chapter 7 or Chapter 13. And so I understand a lot of this. A lot of people think it's too good to be true. But I would just say, just educate yourself. And one of the great ways to educate yourself is through a free consultation with a bankruptcy lawyer. And, most bankruptcy lawyers, certainly me, offer free consultations with no obligation. So just to get the information about that option that is available to you, even if you don't intend to exercise it, you at least know what your rights are, and you can at least keep it in your back pocket as a plan B or a plan C or a plan D. But just assuming that the court's going to take all of your assets and repossess your vehicle, it's just a complete myth.
Thank you for all the clarity in this, because I think it's really complicated, and sometimes we try to go on our own, and it's difficult to understand. So thank you for today. Thank you for this explanation. And thanks for listening to Breaking the Debt Cycle with attorney Michael Sheridan. If you're worried about your car or thinking about bankruptcy, Mike can help you weigh your options and protect what is most important to you. Visit atlasbankruptcy.com to book a consult and take those first steps towards financial freedom. And always like this page, subscribe, and come on back next week.
Thanks.